What's the difference between an invention embodiment and a patent claim? Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. I'm answering questions today from the comments section. Welcome back to my channel. An invention embodiment is the organization of specific elements in your invention. For example, my invention might be a doorknob. And different embodiments of that doorknob might include, for example, metal doorknobs, wooden doorknobs, sculptured doorknobs, or doorknobs that are shaped as a hook. These are all different embodiments of the doorknob, and it may be possible, depending on exactly what my invention is, for me to include all of these different embodiments and protect all of these different embodiments in the same patent application. Now, a patent claim is something different. A patent claim is an ordered listing of elements at the end of a patent application or a patent that describes exactly and specifically what I claim as my invention. Now, sometimes patent claims can be a little difficult to read, but generally the patent claim contains the minimum set of parts that I believe comprises my invention. For example, I might claim a beautiful and decorative bicycle containing the following elements: a bicycle frame with two distal ends, wheels connected to each end of the bicycle, handlebars connected to the front wheel of the bicycle, and most importantly, handlebar streamers connected to each of two ends of the handlebars. Now, different embodiments of my decorative bicycle might include a bell attached to the handlebars, or stickers on the handlebars, or maybe flowers painted on a basket connected to the front of the handlebars. The idea is the different embodiments described in the patent itself are all protected by the claims recited at the end of the patent. Okay, next question. John is CEO of a small startup. What are the pros and cons of assigning our first provisional patent application to the company? We have 3 inventors on the patent application. Okay, as a practical matter, you want to get the inventors to sign the assignment and get the assignment registered with the patent office, recorded with the patent office, before the inventors leave the company. It's especially common with startup companies for inventors to come and go, especially in the early stages. And you want to make sure you collect the assignments and the signatures on all the documents before anybody leaves. It's so much easier to collect signatures while they're with the company than to try to track them down and convince them to sign later. And then, as a legal matter, as CEO of the company, you're a fiduciary to the company, and your job is to protect shareholder value. And one of the ways that you can do that with respect to intellectual property is to make sure that the patent assignments are recorded in the patent office and that all your patent assignments are in order. As far as cons go, sure, there'll be some extra cost paying your patent attorney or staff to collect signatures and to record the assignments in the patent office. But actually, there's no real question. You should get this done. Jim writes, would a Canadian apply for a provisional patent application in Canada or the US? First of all, Canada doesn't have a provisional patent application program. So if you want to file a patent application first in Canada, then you'll need to file a utility patent application. The US does have a provisional patent application program, and the way the provisional patent application works is that when you file your US provisional patent application, it creates or holds a priority date for you based on the date of filing of your application. And so long as you file a utility application within 12 months of the priority date, that is the date of the filing of the provisional patent application, your utility application gets the priority date of the filing of the provisional application. The important thing here is, though, that you have up to 12 months to claim priority in the US provisional patent application by filing a utility patent application. It's also useful to know that unlike the United States, Canada does not have a foreign filing license requirement for filing a patent application from Canada into the US. many countries have a requirement that if you're a citizen of that country or resident of that country or invent something in a specific country, you're required to first file a patent application in that country or get permission. We call this permission of foreign filing license. You're required to get permission from that country before filing outside of the country of invention. The US does have this requirement. Canada does not when filing patent applications into the US. Now, the decision as a Canadian whether to first file a utility patent application in Canada or a provisional patent application in the United States is really a business decision. I'm not a Canadian patent attorney, but from a business standpoint, I can suggest that you should look at where the product is being manufactured and also where are the majority of your sales going to occur. Will there be enough sales in either country to support filing and prosecuting a patent application in that country? You're very fortunate as a Canadian to have some options, and you may want to talk to a Canadian patent attorney to see what some of the advantages of filing a Canadian patent are. Anyway, good luck with your product. Thank you so much for the question. Next question, Raymond asked the question, if I design a part that I want to soon get manufactured, molded, or 3D printed, do I still use a utility provisional or should I be selecting another such as a design non-provisional? Okay, I'm going to change the question just a little bit because we've already talked about provisional patent applications earlier in this video. So I'm going to answer the question choosing between a utility patent application and a design patent application. What are the differences and which are appropriate to choose in this particular example? Now, the requirements to get a utility patent are that the invention must be new, it must be useful, and it must be non-obvious. Now, by contrast, where utility patent applications protect useful inventions, design patents protect ornamental inventions. The requirements for getting a design patent are that the invention must be new, it must be ornamental, and it must be non-obvious. Now, an example of a famous ornamental design is my childhood favorite car, which was the XKE Jaguar. The shape of the front end of the car was beautiful and sexy, one of the most beautiful cars ever built. That front end design was protected by a design patent. Now, in contrast to the beautiful industrial front end design of the car, there was also a mechanism for raising and lowering the convertible roof of the car. This mechanism was also patentable so long as at the time it was new, useful, and non-obvious. So the distinction to keep in mind is that industrial design patents protect ornamentality. Utility patents protect functionality. So Raymond, the question that you've raised is whether the part that you've designed and molded should be protected by a design patent, protecting the ornamentality of the part, or whether it should be protected by a utility patent, protecting the usefulness and functionality of the part. Now, it is possible for a product to be protected by both a utility patent and a design patent. For example, you may have a lamp that has a beautiful and unique shape. The shape of that lamp could be protected by a design patent, where that same lamp may have an on-off switching mechanism that's new and useful and non-obvious. That is a new and inventive on-off switching mechanism. In this case, the utility patent protects one aspect of the lamp, that is the utility of the lamp, while the design patent protects the ornamentality of the lamp. There's a lot of confusion in the marketplace right now between design patents and utility patents, and this distinction is very important to understand. Okay, that's all the questions for today. If you have some additional questions that you'd like answers to, put them in the comments section below. If you need some help with your company's patent applications or patent portfolio, I'd love to help. Reach out to me at the email address below. Thanks for watching. I'll see you over on the next video.